We receive many phone calls, emails, texts, that sort of thing from people inquiring about medical malpractice. The purpose of this video and this discussion today is to help people who are considering a medical malpractice case or have a reason to consult a lawyer about medical malpractice. In Florida, there is a procedure that's been established that the legislature has adopted in law that requires us to send a notification to the physician or the hospital or healthcare provider that we're going to initiate a medical malpractice action, and they are allowed 90 days to evaluate their exposure and decide if they want to try to settle the case or refuse to settle the case and defend a lawsuit that will be later filed. The notification time allows the person who a claim is being brought against, or the hospital, healthcare facility, to conduct an investigation. In fact, the law requires them to conduct an investigation regarding the claim. The lawyer who brings the claim, that would be like our firm bringing a claim, we're required to do a very comprehensive investigation before we even initiate the letter to the physician or hospital that we're going to bring a suit against. And in that investigation, we have to retain the experts that are in that same healthcare field. If it's a hospital, then hospital experts. If it's a particular physician, say a neurologist, then we have to have a neurologist board certified. We generally try to find people associated with teaching institutions, academic institutions who are also in clinical practice, people with really prestigious credentials to evaluate situations that we encounter where people come to us for help. We don't try to find an expert that's going to say what we want them to say. That is not the right way to practice law, and it's not fair to the healthcare providers or the physicians that we have or that we might bring a claim against. Our firm feels that we have to have a board certified specialist in that same field who fairly looks at the records, has no conflict of interest, and helps us understand whether there's been a violation of the rules and regulations that pertain to physicians and hospitals. It's called the standard of care. And when there is a standard of care, it's a national standard, a national understanding of what a physician in the same circumstances would likely do, or that a hospital in the same circumstances would likely do. It is called a standard of care, and if there is a violation of the standard of care, it's a basis to bring a medical malpractice claim. And that's just the language that's used that basically refers to negligence, the failure to use reasonable care. But the failure to use reasonable care requires an analysis of what a similar healthcare provider would do that was adequately and properly trained under the circumstances. If you go into a hospital and you have an amputation because of a diabetic condition of a right leg, and the surgeon, by mistake, cuts off the left leg, the average person would say, well, that's obviously a violation of the standard of care. Would appear that way, of course. But in order for us to bring a claim, we have to present all these records to a specialist, another board-certified surgeon, and ask them to review all these records to make sure that we understand what's really happened and that we don't jump to a conclusion that is erroneous or is fraught with mistake or error. We have to be careful about that, and I use that example of amputation of a leg, but it applies to any kind of a medical situation in which it appears that there's been a breach of the standard of care, appears there's been a mistake. We don't jump to conclusions and then go try to find somebody to corroborate that. We start from scratch, zero base, and we send it to physicians that are similarly situated in terms of their credentials and their backgrounds. And we say, when you look at these records, do you see a breach of the standard of care? and invariably they want to know what's happened to the patient or our prospective client. But we ask them to look at these records and look at the relevant records to see if there's been a violation of standard of care. So after that, the physician, assuming there has been a violation of standard of care, they prepare an affidavit for us that says that there's been a violation of the standard of care, and they point out precisely what that breach of the standard of care was. So we have that letter, and we have an affidavit, and we send the whole package to the healthcare provider, to the physician or hospital or whoever's involved. And then they have the 90 days to evaluate their exposure and decide if they want to settle the claim or if they want to defend the claim. Sometimes in that 90 days, they'll say they want to arbitrate or they want to mediate or they want to do something else. And then depending on the law of that particular case or circumstance, we consider that. We discuss it with our clients. We explain to them what these options are. And then the client tells us what they would like us to do. If they ask our advice, of course, we give it to them. And then we proceed to go forward with the case. So let's just say they deny it and they say, we do not think we have breached a standard of care, and we have an expert that we've consulted, and our expert says there's been no breach of the standard of care. What happens next? A lawsuit is filed, and the lawsuit will name the particular defendants that have received the notice that we sent with our expert affidavit. And in that lawsuit, we set forth precisely what we think has happened and why we think there's been a breach of the standard of care. The lawsuit is then served, that is, by a formal service of process with a deputy who goes and delivers the papers to the healthcare provider. Sometimes lawyers will say they'll accept the papers, that is, defense lawyers will say they'll accept the suit papers, and so that avoids the embarrassment or inconvenience of serving the physician. We prefer to do that. We don't like to cause a physician or a hospital any unneeded embarrassment. There's no point in that. But sometimes the hospitals, particularly the hospitals, most doctors won't, but sometimes the hospitals will say, hey, we're not going to agree to have our lawyer accept these papers. You have to bring them and you have to serve us. So we do. We hire a professional service person, and they go and they deliver the papers to the administrator of the hospital. Then they have a period of time in which to answer the complaint. That's called an answer, and it's a formal written document that says we admit that, number one, that we're a hospital. We admit, number two, that John Jones here was a patient. We admit, number three, that the physician so-and-so was in the hospital at the time. Number four, we deny, however, that this physician committed malpractice and breached the standard of care. So they can admit or deny the various allegations of the complaint. And then we have the complaint framed up and the answer framed up. And now we have the parameters of the lawsuit. And that is, within this complaint and this answer, we're going to dig down into it. And how do we do that? Well, one of the things we do is we take depositions. Depositions are formal statements of various witnesses, including the people being sued and the people suing, under oath before a court reporter, answering questions from the lawyers. That's called a deposition. Another thing we can do is use certain written requests to get records from other facilities, perhaps, or relevant records, and the defense can do the same thing. They can get, for example, employment records if we're saying that our client has lost employment opportunities and lost income. They can verify that. They can verify other things in a written fashion, as can we. It's called discovery. And discovery really is not the right name for it. It's historically been called discovery. It's a process of getting information. But most of this is information we already know about, and so we're just formally getting it. Sometimes, though, in the taking of a deposition, for example, we'll learn something we didn't know about. But anyway, the big picture is called discovery, and it's a time where you just find out everything. You find out everything about your case and everything about the other person's case, that is a defense case, based upon the kinds of questions that are asked and the depositions that are taken, and actually you learn more about your own case. when the depositions of your clients, for example, are taken, because you might not know something that the other side knows. And the idea here is for everybody to learn as much as they can so we don't have a big surprise party when we go to trial. Everybody, in theory anyway, everybody is well acquainted with what's going on. Everybody's well acquainted with each side's position. They just don't agree. Enter the jury. So when a trial is conducted by the judge, he will impanel a jury. There's a process for jury selection. I won't go into it on this video, but a jury is selected. And then a jury hears all of this evidence, and they hear from the expert witnesses on both sides. They hear from the plaintiff, the person bringing the lawsuit. They hear from the defendant, the person that's being sued. And they weigh and evaluate all of this evidence, and then they retire and they deliberate. People have seen this on television, and many of you probably have been in a trial, or seen a trial rather on television. Maybe some of you have actually been in a trial or actually been on jury duty, so this will be all quite familiar to you. A jury deliberates and they return a verdict. And the verdict is, we the jury find that the defendant hospital was negligent or not negligent. We find the physician was negligent or not negligent. And assuming that they find that both are not negligent, they don't ever reach a question of what are the monetary damages that should be paid to the person who's brought the suit, the patient or the plaintiff. Okay, same thing. The patient has been the person that was injured, and they're called the plaintiff in the lawsuit. Now, if the jury says we find for the plaintiff and find that the physician was negligent and the hospital was negligent, then they allocate between the two the percentage. 50% to the hospital, 50% to the physician. This is just hypothetical. It can be anything from 99% down to any number, okay? Must total 100, okay? Pretty obvious that the allocation of fault must equal 100%. It can be anything. It could be 60% to the physician, 40% to the hospital. A jury makes that determination, okay? But they then determine who's going to pay and how much they're going to pay, and that's included in the damages portion, that we find the plaintiff's total damages. Let's just take this arbitrary number and say it's $1 million. The jury finds for the plaintiff for $1 million in damages and finds the defendant hospital 60% at fault, the physician 40% at fault, which means that the physician will pay 40% of the $1 million or $400,000, his insurance company. All these physicians have insurance, and hospitals do too. And the hospital and their insurance company will pay the $600,000, so the total will be $1 million. Then what happens? Well, they don't just write a check. After that verdict comes in, both sides have a chance to decide if they like the verdict and if they'll accept the verdict. And if they decide they don't like the verdict, either side can ask the judge to give them a new trial, that something happened during the trial they didn't think was fair, or the court made a ruling that they think was unfair and it affected the outcome of the trial, and then the judge decides if there's going to be a new trial. And if there's a new trial ordered by the judge, the whole process starts all over again. But let's just say the judge denies a new trial and enters the judgment for $600,000 against the hospital, $400,000 against the physician, and it's appealed. What is appeal? Well, either the hospital or the physician or both can file a notice of appeal. Actually, the plaintiff could file an appeal too. If the plaintiff had a $25 million case and got $1 million verdict, the plaintiff might want to appeal. But let's just say in this case that the defendants, both defendants, are not happy with the verdict and they want to appeal. What happens then? Well, that process in Florida can take realistically a year. By the time the papers are filed that are required with the appeal, the court reporter has to type up the whole record and present it to the appellate court. The appellate court that we deal with in Florida are district courts of appeal. There's 5 of them in Florida, so it depends on where we've tried the case. If we tried the case in Central Florida, it might go to the 2nd district or the 3rd district. If we tried it in Fort Lauderdale, it goes to the 4th district or whatever. In Northwest Florida, all the way to Gainesville, clear across to Jacksonville, it goes to the 1st District Court of Appeal. And what is that? That's a court in Tallahassee. They're primarily housed in Tallahassee. Sometimes they'll travel out to other areas in the First Judicial Circuit. But the appellate court is comprised of 3 judges that are on a panel of a number of judges. I don't know how many are in the district court now, 19 or 20 maybe. And 3 judges are assigned to each case, and they might, for example, agree to have the lawyers come and orally present their case and discuss the case with the court. The 3 judges might. It's called oral argument. Sometimes that happens. Or the court might just decide it based on the briefs. What's a brief? A brief is a written document that outlines the position of the parties, and it's presented to the appellate court. Both sides present these briefs and outline their position. So the appellate court could read these and make up their mind and say, okay, we rule that we uphold what the trial judge did, or we reverse it. And let's just say that the appellate court, in this hypothetical we've been dealing with, says that they're going to reverse it. Well, they reverse it. Sometimes they'll write a fairly lengthy opinion. Some don't have to write a lengthy opinion, but sometimes they'll explain precisely why the trial judge made a mistake. And that something happened in the trial. Maybe it was the lawyers. Maybe it was part of the evidence. Maybe it was something the trial judge did. But the appellate court, these 3 judges that review all this, reached a conclusion that a fair trial did not result from what happened. And they have a number of options, but one of the options is to remand it, send it back to the trial court that initially had the trial, and we start all over again. Okay? That process can take a long time, from beginning when the client first calls us to the point where I've just discussed with you on the remand by the appellate court, where you're starting all over again with the trial. It can take years. We had one medical malpractice case that resulted in about a $10 million verdict over the period of time. It built up to $10 million, but it took 10 years to do that. And maybe it wasn't 10 million, maybe it was 9 million, but it was 10 years. I recall that specifically because it has been a number of years ago. But in any event, they can take a long time. And we tell that to people when they call us, that this is not going to move fast. All of the incentives that are involved are for the defendant to delay the case as long as they can, especially insurance companies. The longer they hold the money, the more money they make. And the longer they can make the plaintiff wait to recover, the more money they make. The risk for them is they may end up paying way more than they could have paid to settle the case if they delay and delay and delay, and then ultimately a verdict is rendered, and the verdict is very high, much more than they thought they were going to have to pay. So it's some risk for the insurance companies. But I would say, as a general rule, the insurance companies are rewarded for delaying the case. Our judges press everybody to get these cases concluded and finished up. But the practical effect of it is that the insurance companies drag their feet as long as they can. Medical malpractice cases are difficult. If you'll notice that we encounter this many times. So I digress for a second. We encounter this many times. People call us and say, I was in a very bad accident and I was badly injured. And I think that as a result of this, something happened in the hospital that made my injury much worse, and I want to discuss with you about a medical malpractice case. And so we say, well, what happened? Because the person who caused the accident under our law, is responsible for everything that follows, including anything that happened in the hospital that was a bad outcome. So then the question is, what about the accident, the automobile accident situation? Oh, well, I have a lawyer for that. And then we always say, you do? Well, why isn't that lawyer representing you for your medical malpractice case? Well, that lawyer says he just doesn't do that kind of work. So here's the fact with this, which isn't pleasant, but we encounter it often enough, and I'll pass it on, that the lawyers are taking the easy case. The easy case is the automobile accident, may result of a liability insurance policy of, say, $300,000. Person has a $2 million claim. The lawyer gets the $300,000 and they settle it right away and they charge $100,000, and then they tell the client, well, I'm really not qualified to handle this medical malpractice. You need to find somebody like Kerrigan, or Kerrigan Estes, and let them take a look at this thing, because at that point the lawyer's taken the cream off the top, and they now have a client that's coming to us facing years of litigation, when in fact we can't take that case because it's been compromised by the lawyer who's been representing them. Okay? Because we would have approached the case entirely differently had we had the client call us initially. And so we reject those cases. We do not get involved in cases where people have hired another lawyer and that other lawyer has rushed to get the case settled, and maybe not rushed, but gotten the case settled, gotten their money, because the easy money is the automobile accident case. When you see these ads, and it's amusing to me to see the ads about, I'm an expert in truck cases. I'm an expert in drunk driving cases. Well, what they're saying is they're an expert in cases in which there's a lot of money involved. Because in trucking accidents, there's almost always major liability insurance policies. And in drunk driver cases, a 10th grader could try the case, because juries get angry at somebody who's drunk and gets out there and hurts somebody, maims them, or kills them. Drunk driving cases are simple cases, and they're very lucrative for lawyers to get. So same thing with trucking accidents, and those are the easy cases. The medical malpractice cases are exceedingly difficult, and they can't be just cavalierly done by sending a letter to a doctor and saying, I want $300,000. I mean, it's just not going to work. Might work in an automobile accident case, a drunk driver case, or truck driving case. So really what these ads are saying is, listen, I'm an expert in what will be an easy case and lots of money. Now, maybe they have some level of expertise. I'm not saying they don't, but that's why they're advertising for it, because those cases pay really well, and there are big rewards. And if you'll notice, you don't see many lawyers advertising for medical malpractice. Some, but not very many, because they are very difficult and they take a long time to bring to conclusion. I hope this has been helpful to you. I'll conclude by saying this, that not every bad outcome is a medical malpractice at all. Bad outcomes occur in medicine, and through no fault of anybody. But here's the bulk of the calls that we get. The bulk of the calls we get are where there's arguably a mistake that's been made. We call them almost died cases. Person recounts this incident in the hospital. It's bad, they were treated poorly and wrong medication, whatever it might be, and they tell us, and I almost died. No lawyer takes these cases that knows what they're doing in medical malpractice unless there are very serious long-term damages. They just don't accept them because they are so expensive to undertake and they're so difficult. And so we turn down many, many cases. And it's heartbreaking, really, because I look at them and I read them and I understand that people have been treated terribly. Maybe insubordination in the hospital, or they've been treated in a degrading and humiliating fashion, or the doctor didn't care and didn't show back up, and somebody had to substitute for the doctor, and the doctor was rude, and on and on and on and on. That is not going to support a medical malpractice case. You have to have a serious breach of the standard of care, a violation of the standard of care, before a lawyer is going to undertake a claim against a physician. And for us, it has to be a very significant, lifelong injury. And that is particularly true when we deal with children and young people, that where there is an injury that they're going to be dealing with the rest of their life, we will undertake those kinds of cases. Whereas somebody that's going to have a debilitating problem, but they're in their late 80s or 90s, by the time you finish the litigation and you spend all the money and you get to the conclusion of the case, the client really can't enjoy any of it. They've just been worn out from the process. I hope this has been helpful to you. You can call us about a medical malpractice inquiry. We don't charge anybody to look at them. We just don't accept very many of them. Of 1,000 cases that we review, and we've looked at these very numbers in the past. When we get to 1,000 cases, review them, we might accept 15 to 20 cases that actually result in a formal notification of a lawsuit. But we're happy to talk with you about it and take a look at what you've got. If you want to call us, there's no obligation and no charge for us to do that initial evaluation. And then we might go further and get medical records and all if we think the case warrants it. Thank you very much for watching this video. This is Bob Kerrigan from Kerrigan Assist Rankin McLeod and Thompson across the Panhandle.